An act against the Constitution is no law at all. It's void. This long-forgotten and essential principle to the American Revolution was central to President Thomas Jefferson's response to the hated Sedition Act of 1798. So on this episode, we're going to explore how Thomas Jefferson viewed his oath to the Constitution as requiring him to treat government censorship as null and void, regardless of whether Congress, the federal courts, or anyone else agreed with him or not. But first of all, before getting to that, welcome and thank you for joining me here on the Path to Liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Wednesday, January 22nd, 2025. Now, when Thomas Jefferson became president in 1801, he immediately addressed the Sedition Act. He made it a priority, which he considered a direct violation of the Constitution and, of course, the First Amendment. And in a letter a few years later to Abigail Adams, he explained that he considered the act as no law at all, and he took swift action to halt its enforcement without waiting for Congress to repeal it or the federal courts to strike it down. Here's how Jefferson put it. I discharged every person under punishment or prosecution under the sedition law because I considered and now consider that law to be a nullity, as absolute and as palpable as if Congress had ordered us to fall down and worship a golden image. Little Jeffersonian flair there, but I think you catch the drift. It's null and void, and if he enforced it, he's violating his oath. He's violating the Constitution, and he wasn't going to participate in that as well. Now, he explained that his oath to the Constitution made it a duty to take this type of an action to prevent the enforcement of such censorship laws. He said, it was as much my duty to arrest its execution in every stage as it would have been to have rescued from the fiery furnace those who should have been cast into it for refusing to worship their image. I believe he's referencing a biblical story from the book of Daniel. I'm not 100% certain on that. Maybe someone can point me to the right spot on that one, but that's what I believe he was pointing to. But then on top of it, he made it very clear that the specifics of the prosecution, what the person did under the Sedition Act, had no impact on his actions. Here's how Jefferson put it. It was accordingly done in every instance, without asking what the offenders had done or against whom they had offended, but whether the pains they were suffering were inflicted under the pretended sedition law. I think just from that short series of sentences to Abigail Adams in 1804, Thomas Jefferson's lesson is very clear. The Constitution is the supreme law of the land. The Constitution is the standard, not just any old federal act or federal law or judicial opinion. No president should ever allow unconstitutional acts to be carried out on their watch. But this wasn't something that Thomas Jefferson made up at all. This was an essential principle of the American Revolution. This was one of the rallying cries of the Revolution, that acts outside the Constitution are void and should be treated that way as well. And for that, we want to go next to James Otis Jr. In his speech, very long speech, his arguments against the writs of assistance in February of 1761, which we can point to as, in essence, the beginning of the primary controversy between the colonies and Great Britain. And one of the many things that James Otis Jr. said there, and this is in reference even to the unwritten British Constitution, is that an act against the Constitution is void. But it wasn't just James Otis. There are many others. I've just got a handful of examples here. John Adams, who signed the Sedition Act into law when he was president, took a very similar position in response to the Stamp Act in December of 1765. He said, the Stamp Act, I take it, is utterly void and of no binding force upon us, for it is against our rights as men and our privileges as Englishmen. And you can also see how Jefferson's letter to Abigail Adams very closely tracked the perspective that John Adams was having here in 1765. He said the Stamp Act was made where we are in no sense represented, therefore no more binding upon us than an act which should oblige us to destroy one half of our species. And then, of course, during the height of the American Revolution, this is the years from 1760, 1761, through the shot heard round the world when the War for Independence started in 1775, Thomas Jefferson wrote a summary view of the rights of British America in 1774, using this same kind of a principle. And he's talking about all kinds of acts that the British had passed for a long time, even before 1760, which they considered a nullity and void. He said, "We do not point out to His Majesty the injustice of these acts with the intent to rest on that principle, the cause of their nullity. Instead," Jefferson said, "the true ground on which we declare these acts void is that the British Parliament has no right to exercise authority over us." Period. And here from my article that I wrote discussing that in more detail, Jefferson was pointing out that it wasn't so much the negative impact of these British acts that made them problematic. He was asserting a more fundamental principle. Whether good or bad, these acts were null and void simply because they crossed a line in the sand and usurped power that rightly belonged to the people of the colonies. And of course, I covered this in much more detail in an episode just this last fall, Null and Void, Thomas Jefferson's 1774 Radical Declaration. I think you should definitely check that one out if you haven't yet. It's one of my favorite ones recently. But this principle wasn't just part of the American Revolution. It was actually carried forward as a leading argument of supporters of the Constitution during the ratification debates over the Constitution in 1787, 1788. I've got a few highlights from that as well. Roger Sherman, in December of 1787, said all acts of the Congress not warranted by the Constitution would be void, nor could they be enforced contrary to the sense of a majority of the states. I mean, we can get into a lot of detail from that simple paragraph, but we also can recognize that just because you call something void, the federal government isn't necessarily going to stop trying to enforce it. So something else has to happen. That's another episode that we can get into at another time. But again, the principle of acts beyond the limits of the Constitution are void in principle. How do you make them void in practice? Well, Jefferson as president did what he could in his role, and we'll get to that in a few minutes as well. Here's Oliver Ellsworth, who later became Chief Justice of the United States. I think he was number 3. He said, if they make a law which the Constitution does not authorize, it is void. And even Alexander Hamilton got in on the game during those ratification debates here in Federalist number 78. He said and Hamilton, when he was on, he was really, really a great writer. He said, there is no position. That's from someone who is no fan of Hamilton at all right here. There is no position, wrote Hamilton, which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. Period. End of story. And then he even takes it further. If you want to deny this, then you're taking a pretty crazy position. He said to deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. TLDR, you're insane if you think anything other than this. That's the Hamiltonian take. And here he is in Federalist number 33, also pointing out, he's talking about the supremacy clause specifically in this discussion, but he's saying, well, what if they go beyond those limits? He said, acts of the large society, which are not pursuant to its constitutional powers, will be merely acts of usurpation and will deserve to be treated as such. And the deserve to be treated as such is really, really the important point here as well. So Thomas Jefferson was really just putting into practice these radical principles that carried all the way back to the beginning of the American Revolution that were prominent in the ratification debates, primarily by the Federalist side. They were saying, hey, you don't have to worry about government going beyond its limits because, well, if they do, it's void. And then the people in the several states, well, they can make them void in practice as well. So this was really, really a widely accepted and understood view. And so that brings us to the Sedition Act of 1798. And here from an article a couple of years ago, enacted on July 14, 1798, the Sedition Act represented a dramatic curtailment of free speech and the press, taking censorship to unprecedented levels by unprecedented, I guess, would be correct for a free society. Certainly, governments all through history, as Benjamin Franklin pointed out, are waging a kind of a war against the liberties of the people. So this isn't unprecedented in that way, but it certainly was a terrible, terrible act signed by John Adams. It criminalized not just direct attacks on the government, but also speech and attacks by speech, that is, but also speech that could merely, quote, bring them or either of them into contempt or disrepute. So if you said stuff that would bring the government people into disrepute, and that's a very gray area there, what if it was true? Well, you could be punished under the Sedition Act. The act further extended its reach by criminalizing expressions with the intent, quote, to defame the said government or either house of the said Congress or the said president. As an aside, they expressly did not include the vice president. That's because it was Thomas Jefferson. This broad and sweeping language targeted not only statements proven to be false, but also any criticism that might tarnish the reputation of federal institutions or officials. In other words, one of the worst attacks on the right of free speech, the right of the freedom of the press, and the First Amendment, the delegated and reserved powers of the Constitution, which we'll all get to here in just a moment. Now, just one example, I've covered other prosecutions under the Sedition Act in other situations, like Matthew Lyon, who was a member of the House of Representatives. He went to prison. He won re-election while in jail because he was punished. He was seen as a hero for being punished and put into prison for exercising his rights. Here from the National Archives, they point out that David Brown, an itinerant Republican speaker and writer, was arrested in March of 1799 under the Sedition Act. And get what he got arrested for allegedly inciting the citizens of Dedham, Massachusetts, to put up a liberty pole that carried a sign declaring this. No stamp. Now, he didn't put up the pole. He just encouraged other people to do it, and he still got prosecuted for this. No stamp. No sedition, no alien bills, no land tax, downfall to the tyrants of America, peace and retirement to the president, Mr. Adams, long live the vice president, that's Jefferson, and the minority. So he was denounced by the Federalists as inciting sedition. And then he was charged and he was sentenced in June of 1799 by Judge Samuel Chase to 18 months in prison, and he was fined $400. I went to government-run school. I'm terrible at math. There's no way I can figure out what the inflation rate, what would that be in modern dollars? If you know, please let me know in the comments. $400 and 18 months in prison for, quote, sowing sedition in the interior country. Now, from what they say here at National Archives, he got the harshest sentence imposed under the Sedition Act. And although he completed his prison term in December of 1800, he remained in jail because he could not pay the fine. He didn't have the money, so he had to keep staying there, and he was going to rot really forever until he could pay it off. But, well, John Adams didn't stay in office forever. Now, I'm going to discuss how Thomas Jefferson responded to this, not only when he was vice president through his secret drafting of the Kentucky resolutions that were passed in 1798, but his actions going a little bit further, discussing what he mentioned to Abigail Adams in 1804, how he addressed it as president. Basically, his oath required him to not enforce the Sedition Act. because then he would be helping people violate the Constitution, and that's not something that would be acceptable. But I wanted to also point out that all the stuff that I'm mentioning in this episode, of course, I've already referenced another article or two. There's some original source documents. There's another podcast for you to check out. They will all be included in the show notes for the blog post that we publish for this episode, like we do for every single episode, and that'll be live a couple of hours after this live stream is done over at 10thamendmentcenter.com/path to liberty. It's all spelled out. My buddy Alan Mosley, I'm very grateful for the very consistent and solid work that he does in getting the blog post organized so you have a set of resources. I don't think I would have. I used to do it myself, but man, I sometimes need to find time to check out, call my mom, maybe watch a TV show or get some normal amount of sleep. So Alan has really been awesome taking some of this off my plate. And hopefully I've got some other work for him in the near future. But he'll get the blog post for this episode with all the show links in it, generally in the order kind of how I go through it in the episode. That way you can read, learn more, watch, listen, learn more in context on your own time. Again, that's 10thamendmentcenter.com/path to liberty. Now let's get to Thomas Jefferson again, his opposition to this hated Sedition Act of 1798. First of all, let's talk about his Kentucky resolutions, where he rooted his opposition to the Sedition Act actually first, not in the First Amendment, but in the 10th Amendment. He said, resolved, that it is true as a general principle and is also expressly declared by one of the amendments to the Constitution. So first of all, he's affirming that the structure of the Constitution was one of delegated and reserved powers, and then they reaffirm that through the 10th Amendment. He said that it is true as a general principle and is also expressly declared by one of the amendments to the Constitution that the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. And Jefferson continued, and that no power over the freedom of religion, freedom of speech, or freedom of the press was delegated to the United States by the Constitution. So they have no say over this in the first place. So he starts it out with the 10th Amendment argument, just like Jefferson would do on virtually everything. And then he also highlighted that beyond this framework of delegated and reserved powers, the people were so concerned about these essential liberties, these rights, these freedoms, that they added a more, what he called, special provision to really hammer it home. He said, and that in addition to this general principle and express declaration, another and more special provision has been made by one of the amendments to the Constitution, which expressly declares that Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press. He said, thereby guarding in the same sentence, under the same words, the freedom of religion, of speech, and of the press. And so he continued saying libels, falsehood, and defamation, equally with heresy and false religion, are withheld from the cognizance of federal tribunals. This shouldn't even be up for question for anyone in the federal government at all. And then he went on to point out that because of this, that act of July 14th, 1798, which does abridge the freedom of the press, is not law, but is altogether void and of no force. That same principle of the American Revolution that everyone from Hamilton and everyone else recited throughout the ratification debates, it is no law, it's altogether void and of no force. And once Jefferson was president, he was really in a position to personally prevent enforcement of the Sedition Act of 1798, just like he described things to Abigail Adams in that 1804 letter. But he also reiterated that same view in many other letters during his presidency and after it, that his oath to the Constitution required him to treat unconstitutional laws like the Sedition Act as void. Here he is in a letter to Edward Livingston in November of 1801. He said, I found a prosecution going on against Duane for an offense against the Senate, founded on the Sedition Act. I affirm that act to be no law, because in opposition to the Constitution. and I shall treat it as a nullity wherever it comes in the way of my functions. I have therefore directed that prosecution to be discontinued. And here he is in a letter to that same William Duane, in May of 1801. He said, whenever in the line of my functions I should be met by the sedition law, I should treat it as a nullity, that therefore even in the prosecution recommended by the Senate, if founded on that law, I would order a nulle prosequi. I believe that's how you say it. It's basically an old Latin legal term that means will no longer prosecute. So he's telling this guy who was charged under the Sedition Act that, well, as long as you're being charged under that, I'm going to tell them to stop the prosecution. Here he's in a letter in 1814 when he was not president anymore to Gideon Granger. He said, it is well known to have been a tenet of the Republican portion of our fellow citizens, those who were in support of federalism versus a national system, that the sedition law was contrary to the Constitution and therefore void. On this ground, I considered it as a nullity wherever I met it in the course of my duties. Now, he wasn't able to control what happened in other branches or in other areas, but if it came across his desk, in essence, if it required the action or required no action of the executive branch, he said, I directed, well, again, nulle prosequi, end the prosecution in all the prosecutions which had been instituted under it. And even later, in a letter to Spencer Roane, he responded to the suggestion that, well, only the judiciary can have any say about this. This wasn't his role. He said, my construction of the Constitution is very different from that you quote. It is that each department is truly independent of the others and has an equal right to decide for itself what the meaning of the Constitution in the cases submitted to its action, and especially where it is to act ultimately and without appeal. So he's basically saying, look, the judiciary may have their opinion, the Congress may have their opinion, but if we're co-equal branches, no one gets to tell the other what they're allowed to do and what they're not allowed to do. They can share their opinions. Maybe they can convince the executive branch that this is constitutional and okay and you should do all the prosecutions, but he wasn't convinced. And so therefore, he took a different approach. And this is the same thing that he said in a follow-up letter to Abigail Adams later in 1804. He said, you seem to think it devolved on the judges to decide on the validity of the sedition law. But nothing in the Constitution has, and we can read it, obviously Jefferson did, but nothing in the Constitution has given them a right to decide for the executive more than to the executive to decide for them. So the executive branch can't tell the judiciary how to release an opinion or what their opinion should be. They can give it an opinion, but he can't decide for them, and vice versa. Again, this is getting back to checks and balances and independency of each of the branches. The departmental view of the Constitution that people like Thomas Jefferson and James Madison advocated. Jefferson continued, both magistracies are equally independent in the sphere of action assigned to them. The judges, believing the law constitutional, had a right to pass a sentence of fine and imprisonment, because that power was placed in their hands by the Constitution. But the executive, believing the law to be unconstitutional, was bound to remit the execution of it, because that power had been confided to him by the Constitution. In other words, this is the real, they may tell us in government-run schools that we've got this system of checks and balances, but not the way they teach it, not the way that they want us to use it, not the way that we have actually tried, we the people have applied it in for so many generations. The way Jefferson's describing things is the real system of checks and balances. Each branch acts independently of the other. And back to his letter to Spencer Roane, he said, the opinion which gives to the judges the right to decide what laws are constitutional and what not not only for themselves in their own sphere of action, but for the legislature and executive also in their spheres, would make the judiciary a despotic branch. In other letters, he referred to that view as creating an oligarchy, a system of an oligarchy that is ruled by unelected, politically connected lawyers, in essence, that make up the Supreme Court. That's my little add to it as well. But Jefferson's approach to the Sedition Act, while he was president and even before that, I think it highlights three essential principles that we have to keep in mind all the time. First of all, the Constitution is the supreme law of the land, not any old act of Congress, not opinions of the Supreme Court, unless they're in line with the Constitution. That's it. And on top of it, two, each branch is independent. So various branches, various members of each branch may look at things, the constitutionality of various things differently. This is what checks and balances under the Constitution is really all about. And then three, the oath to the Constitution has to be the basis, the foundation. And for Thomas Jefferson, taking an oath to the Constitution meant refusing to enforce a law that he viewed as unconstitutional, even if it meant he was alone in that view. Because when you believe that you're right, you do what you believe is right, whether you can get the courts to agree with you, the Congress to agree with you, the mass of the people to agree with you or not. Now, taking that all together, if you put it all together, I think it is no surprise that the government-run schools don't teach us any of this stuff at all. I didn't learn about any of this stuff in government-run schools. I didn't learn about it in college. None of it. I had to search this out on my own. And that's why part of why we work so hard every single day to reach and teach more and more people about these essential foundational principles. And nothing helps us do this work more than the financial faith and support of our members. If you like the work that we're doing and you want to help us get this information out to more people, you want us to do more of the same, and you want us to expand our work, please consider joining us today. I'd be very grateful for any consideration you can give to becoming a member today. It starts out at just $2 a month. If you got a couple of bucks of that dirty government fiat, please throw it our way over at 10thamendmentcenter.com/members. It's all spelled out, 10thamendmentcenter.com/members. We also have annual, 5-year, lifetime options. You can make a one-time gift over at 10thamendmentcenter.com/donate. No pressure on any of that, but I'd be very grateful for any consideration you can give to joining us or pitching in some way financially today. You can also take a bunch of free and easy peasy steps to help us spread the word, primarily by triggering the algorithms of the mainstream platforms that you may watch or listen on. So like hitting the like button, reviews on Apple Podcasts or any other podcast platforms, leaving comments, subscribing, getting notifications, and especially on platforms, video platforms like YouTube, the more watch time you have for a video, the more likely they're going to show that video to more and more people. Again, thank you so much for watching or listening, whether this is your first episode or you've been here for every single one since day one. I'm so grateful for you spending some of your time with me here today. I hope you enjoyed this episode. I hope it made you think. I hope you learned something. That's more important than anything. And I hope to see you next time here on the path to liberty.